Hello everyone, welcome in. This will just be a quick video discussing the motion to suppress / dismiss in the Alexee Trevizo case. I have gone through it, done a little bit of research, and sat and thought, and I've come to the conclusion my opinion is the parties involved will have to go through all this evidence with a fine-tooth comb, excluding privileged materials in order to preserve a fair trial, minimize possible appeals after a guilty verdict. And obviously I'm biased, I'm hoping for a guilty verdict, but that does not mean I can't objectively look at the facts. I do not believe this case will be dismissed in any way, shape, or form, even though they have to throw that in there as basically a legal formality in this motion to suppress. I came to this conclusion by parsing out in my head because I have seen so much of the body worn camera footage and the hospital footage. What I know, moment by moment, what has happened in this case. If you haven't, you will be able to see what I'm saying when you go back and watch it, by what is privileged and non-privileged. The possible privileged material that they will want to remove from trying to get into evidence in this case would be statements regarding Alexee's medical care and footage of Alexee undergoing any medical treatments. A lot more, in my opinion, is non-privileged because under the law here, let me just bring this up, Mexico state law requires healthcare providers to report deaths, section P right here, if they believe they're due to violence, homicidal injury, regardless of when or where they occurred, and down here on L, any stillbirth of 20 or more weeks gestation unattended by a physician. So, whether or not they knew or thought the baby was dead or alive when put in the bag, they had multiple legal requirements for them to report about this baby. So, non-privileged information here is the finding of the baby, the reporting and telling the officers anything about finding the baby, statements made by hospital staff regarding the baby to law enforcement, footage of the baby on body-worn camera of the responding officers, statements made by hospital staff as to who was in the bathroom when the possible crime happened, hospital hallway footage of the baby being discovered, statements from the doctor and hospital staff to and from Alexee in the presence of law enforcement, not regarding Alexee's medical information, statements made by Alexee on body-worn camera unsolicited by law enforcement despite Miranda. I bring up Miranda because in the motion to dismiss and suppress, they are claiming that the hospital doctor, the ER doctor, basically interrogated Alexee on behalf of the police officers, but that's just not how the law works. The doctor, number one, did not interrogate Alexee. Alexee volunteered all her information, and number two, what you confess to anyone who is not a law enforcement officer is not subject to Miranda. So that just doesn't hold up legally, and they also mentioned her being detained. At the point that she made several admissions, she had not been officially detained, told by law enforcement she was detained. She was just in the same room as an officer and had been told that they had to contact police because they believe a crime had been committed, right? So there is no duty for them to Mirandize her at this point. They were not interrogating her. Her Miranda came at the point that she got arrested, and they were going to start getting her DNA and all other kinds of evidence directly from her. That is when she would be officially Mirandized, or if she had ever decided to speak with the police. They would obviously remind her of her Miranda rights, but she didn't. She ducked them quite often, which is her right, again. So, what was this one? I'm just trying to look at all the little things that I've brought in here. These are all the ways in which they did not breach HIPAA, because that's also been kind of an issue. It doesn't violate HIPAA to have found the baby, to have called the cops, to tell the police that Alexee went into the bathroom and to tell them that the bathroom came out, that was bloody when she came out. This is my evidence showing that the police were required to keep their body camera on at all times during the course of this quote-unquote investigation or their contact with this suspect and witnesses. And yeah, I guess that's about everything. This is the motion to suppress. If anyone wants to see copies of it, you can pause. Hold on, this will be the first page. Second page. I highlighted this right here because that is the exception under Rule 11504, which is one of the rules that they are stating. That is, however you want to put it, there's HIPAA and then there is their state evidence rules, and they're saying that according to their evidence rules, these privileged materials may not be used as evidence in this case, but in fact right here the required reports are when privilege can be broken, and of course I showed you this reporting that these are the required reporting standards, and they met a lot of these required reporting standards. So that just goes to show that a lot of stuff will be admissible. It just regards to her Alexee's health information is the only information that's privileged. Nothing to do with the baby. Right here I got a good laugh when I noticed that they threw every single social media platform plus ones from other countries in there to bolster their claim about the virality of this, as if it's the body cam footage's fault that it's viral and not their client. This is where they show the two HIPAA exemptions, basically permitting hospital staff, if they believe a crime has been committed on their grounds, to call law enforcement. Right there at the bottom of my box that I put that in, you see that that's where they cite Rule 11504, which I just showed you the exception to that rule, which is the required reporting of this infant's death. So this is almost the last page, second last page. This is where they insinuate that the ER doctor was working with the hospital, with the police officers when Alexee was speaking to them. They're obviously really worried about those statements because it's an admission of guilt, and she's pleading not guilty, obviously, so that doesn't play out well to a jury, so they really want those statements thrown out. And for some reason, those are the statements where my mind goes, is that I think legally they're going to try and argue that just because that doctor had been an attending physician to Alexee, her going in that room and talking to Alexee is privilege, and that's not necessarily the case. I believe that the judge will rule in favor of admitting those statements, and the statements that are the damning ones are, it wasn't crying, it came out with nothing, all those statements along those lines. Those are the very damning statements that they're obviously concerned about, and that's why they're highlighting the fact that the doctor went in here, and they're trying to conflate it with a coercion under law enforcement, or that the doctor was working as a law enforcement officer, and that she wasn't Mirandized when she said this. But unfortunately for them, the police officer didn't ask. Alexee willingly gave up that information in front of an officer wearing a body cam. No one asked her to confess, she just said it. These are some of the court cases that they are citing. I did not find them to be super relevant. We'll see how those are ruled on by the judge, specifically because they are having to deal with attorney-client privilege, not hospital privilege under HIPAA. So we will see how that goes. I do not think it's a very solid motion to suppress. I think that it'll get enough of the job done as far as getting what she's rightfully owed out of evidence, which is her personal and private medical information. Her admissions of guilt in front of the officer, unsolicited by law enforcement, I personally believe, in my opinion, will be admissible. And I do think a judge would be fair to make that ruling. It's not biased against her in any way, but unfortunately, she is over the age of 18 and she made an admission in front of an officer. That being said, this has been my opinion on the motion to suppress / dismiss in the Alexee Trevizo case. Please let me know if you have any questions or comments or concerns down below. I am more than happy to respond and talk with you all, and I definitely appreciate the conversation. So thank you so much. It's your girl Friday. See you next time. Okay, bye.